Welcome to StudyAssistant.org video tutorial. Each tutorial is voice activated. This video presentation is on the topic of the concept of offer and acceptance. At the end of this tutorial you should be able to distinguish between offer and invitation to treat or bargain, explain the conditions under which offer and acceptance are communicated, and outline ways by which contracts may be terminated or discharged. The concept of offer and acceptance. As you have already seen, all contracts require an offer and acceptance. An offer must be communicated to the offeree, the recipient of the offer, and it must be intended as an offer. Therefore, expressions that are made in jest, anger, and at a moment without any serious thought cannot be considered a proper offer. Also, an offer must be definite and certain as to its terms. It must be clear, unequivocal, and direct to another party to the contract. It must not be vague, uncertain, or ambiguous. If the offer does not clarify the terms, there is no way that reasonable persons can come to a mutual agreement. Thus, advertisements, catalogs or store flyers are not considered offers. Nor is a for sale sign an offer. They are merely announcements, intended to entertain an offer from the viewer. In legal terms these are considered an invitation to treat. Think of an invitation to treat as an invitation to the general public, who in turn can then make an offer accordingly. However, there are instances when an advertisement might be considered a law. In these exceptional cases, the advertisements contained price, quantity, availability, and details that could lead someone to consider it to be an offer rather than an invitation to treat. Therefore, offers must be communicated. The offeree must also impose the communication of acceptance as well. Acceptance of an offer signifies the person's assent of the offer, which is now a promise. Acceptance may be expressed or implied by the person to whom the offer is made. Acceptance must be absolute, otherwise it is a counteroffer. Acceptance must be done in the mode prescribed and within a fixed time, that is before the offer lapses or is revoked. Acceptance must be for an offer that was communicated. Finally, acceptance is made with the intention to fulfill the terms of the contract. If any of these conditions are absent, it is likely that an offer or acceptance can be terminated. An offer can be terminated because of a lapse of time, by revocation, by rejection, or by operation of law. An offer can only be up for a specified length of time. After that the offer is expired, thus, acceptance must be within this time. If the time was not specified, then the offer is terminated upon a reasonable length of time, and dependent circumstances. An offer can be terminated by revocation. The offerer, the person making the offer, may revoke, cancel or withdraw an offer at any time before acceptance, even if the offerer stated that the offer will remain open for a certain period. An offer is terminated by rejection or refusal by the offeree. However, if the offeree rejects the terms of the proposed contract, but introduces a different set of terms, he or she has now made a counteroffer. A counteroffer, by law, terminates the original offer. Termination of a contract is automatic, based on the operation of law. Thus, the death or insanity of either parties to the contract, destruction of the subject matter of the offer, or a change of law can terminate the offer or make an offer illegal. Another term used to terminate a contract is discharge. Discharge of a contract is common when parties do what is required of them to do under the contract. This is referred to as discharge by performance. The rights and obligation of both parties have now come to an end. However, If only one party performs the promise, he alone is discharged. The other party is guilty of breach. Then there is discharge by agreement or consent, where parties consent to the termination of the contracts. Discharge by agreement may be expressed or implied. Finally, there is discharge by impossibility of performance. There are instances that make it impossible to perform what is promised in a contract. They could be war, death and incapacity, change of law, destruction of subject matter, non-existence or non-occurrence of something. However, impossibility cannot be made up as an excuse to not perform duties. By now you should understand that a contract is an agreement entered into voluntarily by two parties or more, with the intention of creating a legal obligation, which may have elements in writing, or contracts can be made orally. The breach of a contract can cause one party to seek remedy for damages incurred under the contracts. Remedy can be compensation by money or an injunction. Contract law varies greatly from one country to another. Common and civil laws impact contract law.